Tuesday, July 21st, will please come to order, and the clerk will please call the roll.
Calling the roll, Mr. Miller,
Here.
Ms. Simon is absent, Mr. Brady,
Here.
Mr. Germana,
Here.
Mr. Greenspan.
Here.
There is a quorum. Also like the record to reflect that Councilwoman Conwell is in attendance.
Thank you very much. Has anybody signed in for public comment related to the agenda?
No, Mr. Chair, no one has signed in.
Okay. The next item on the agenda is consideration of the minutes from the July 7th, 2015 meeting. Those minutes are in your packet. Is there a motion?
Move to approve.
Second? It has been moved and seconded to approve the minutes from July 7th. Is there any discussion? Hearing none. All those in favor say aye. Aye. Any opposed say no. Ayes have it. The minutes from July 7th, 2015 are approved. Matters referred to committee. First one is ordinance 2015-0012. And please read the item.
Ordinance number 2015-0012, an ordinance amending section 407.27 of the Cuyahoga County Code, establishing recusal requirements for appointees to county boards and commissions, and declaring the necessity that this ordinance become immediately effective.
Okay. Ordinance 2015-0012 on recusal requirements is now before the committee. The legislation was sponsored by the executive. I would call upon the administration if someone would please come forward to explain the ordinance and what your purpose was for bringing it forward.
Hello, council members. Chris Glassburn with the Executive's Office. The legislation before you regarding the recusal requirements for appointees for boards and commissions is meant to address an issue that we have faced as an incoming administration in terms of making appointments. Earlier today, many of you were here and saw that we had a big glut of appointments and we're hoping to get caught up. The current code, section 407.27, prohibits the county executive and county council, for that matter, from appointing anyone to a board or commission if they have a contract, if they have an interest in a contract, if their employer has a contract, or if they're even contemplating any of those entities having a contract. And that is a conflict that is too great of a standard for a number of boards and commissions. For example, this morning, we had the Ryan White, which is council, which helps determine where we spend federal funds for HIV/AIDS victims. That council has as a requirement that some of the individuals on the committee must be patients. Some of the individuals must be providers. Some of the individuals must be healthcare representatives from the field. So if we have a outright, we cannot make appointments, as is currently the code, then we are not in a position to make appointments to a number of boards and commissions, whether you're talking about, for example, the Arts Council or Ryan White or a number of others. So the standard, what this ordinance will do is go to what is reflective in the Ohio Ethics Commission's guidelines for statewide boards and commissions, which is that if you have a conflict, you must recuse yourself. Additionally, this legislation goes further and says that if you do not recuse yourself, that is grounds for the appointing authority, whether that be council or the executive's office, to remove that individual from that board or commission, and actually has warning guidance language that states that if an individual does do that, that we may refer them to the Inspector General.
Okay. Any questions or comments by my colleagues?
I'm a little unclear. I guess I'm trying to grasp it. So give me for an example of what you're talking about. Using the HIV Planning Council.
So under the current legislation, that we have, 407.27, as I said, there are individuals that must be HIV positive and are recipients of Ryan White funds. They would be prohibited from being on that planning council because they have a contractual interest in effect with that board because they receive benefit.
Okay.
So now what they should do and what is federal law, the reason we were able to make appointments is because federal law trumps our code in that instance. But what the new code would do is in that situation would say that individual has to recuse themselves if a vote comes up based on their care.
Okay. And if we do nothing,
If we did nothing, they could not be on the board at all, which causes us for a number of boards and commissions to not be able to make full appointments to those boards because there become positions of impossibilities that we cannot make appointments.
but and I'm still sticking with the HIV group.
Mm-hmm.
But up until this point, we haven't done anything to this, and the planning council was still appointing
In the
their
case
members.
in the case of the planning council, again, it's federal law, so it trumps our county law anyway. But it's an easy, concrete example to explain. Maybe a cleaner example might be, for example, the public defender's office. The public defender is a 5-member board. And generally, you would want some individuals with criminal defense experience. You would want some individuals with probation experience or community experience. If you were, say, an attorney who worked at a criminal defense firm, you would not be, under the current law, be allowed to be on the Public Defender's Commission if you or your firm or anyone at your firm contemplated, either had business or contemplated having business with the Public Defender's Office, which essentially eliminates almost every single active criminal defense attorney. So what you're limiting your pool to only being people who are retired or people who are not attorneys, which may not be in the best interest of that board.
Okay, we have Council President Brady and then Councilman Duran.
Thank you, Mr. Chairman. I think my shorthand on this is that it's not easy to find well-qualified, good people to serve on all of these boards. That people who tend to have expertise also tend to have a reason to have that kind of expertise. And this is to create more flexibility so that it's easier to appoint good people to boards.
Absolutely. And again, I want to emphasize that this standard would be reflective of what the state standard is for their boards and commissions. So we're not freelancing here.
Councilman Duran.
Thank you, Mr. Chairman. I understand and I agree with conflict of interest language because it's part of ethics and we all got to go through the training every year and so on and so forth. However, the board from this morning, these people were appointed specifically to have input on where money is spent. And they were appointed specifically to be connected. So I agree with this language, but I think there needs one more section that says there can be cases where the qualifications to be on this board has to do with being connected to what you're voting on. Do you follow what I'm saying? The administration was kind of limited because these people had to qualify for different reasons to be connected because this was the policy and planning. And they wanted people that were directly involved. So actually what happened is by those qualifications of who should serve on this board, they set it up for conflict because they're saying that they actually wanted people that needed the funds or using the funds and so on and so forth. So basically we had a conflict in there. So that there needs to be an exception in the case where what you're trying to do is have people that are part of, or connected in the conflict. The purpose of that board this morning they wanted people that were practitioners. They wanted people that had family connected. Of course, this says you or your family, any business associates, so on and so forth. Well, the qualifications to be on that board, you had to have these connections. So actually, if we pass this, then these people couldn't do their job on the board because they couldn't be in the discussions, deliberating, formally or informally lobbying. They couldn't do their job of directing how these funds and the interconnections that these people had. They'd be in conflict. So you would have people that really couldn't do the job of the board. So I agree with this, but I think we need, and it's not going to be very often where you're going to have qualifications to be on a board where you're putting yourself into conflict. I don't know how you could word that.
So, Councilman, if I may, the legislation as it's written, I believe will address most of what your concern is, because those limitations are only in the instances where there's a conflict. So say, for example, an individual is a recipient of funds on the Ryan White Board. They would only be limited to not lobbying on situations where the money or the care would directly go to them. They would be, if there was care to other individuals or other providers or other contracts that they weren't a recipient directly of, they could have input on all of that. That board in particular is extremely challenging to manage all the conflicts. I mean, there's no two ways about that. Additionally, this legislation, in addition to being consistent with the guidelines from the Ohio Ethics Commission, I'm not sure we could go much further in terms of allowing additional conflict without being in violation of the Ohio Revised Code for a number of different boards. So I think this may be as far as we can go with that.
Yeah, I understand that to come up with verbiage to allow something where you're actually putting people in conflict, how are you going to do that? That particular case is because of the requirements to be on that board, especially these people that work for agencies that, you know, their employer is at stake in decisions, and they're trying to drum up participation in this own. So they're trying to build up the program in an agency that they're working for. So, I mean, it's putting those people in a direct conflict according to this language. So I don't know if anybody could come up with another section to this that can clarify that as an exception. Because really, you're purposely putting people in conflict on that board. And, you know, if you could craft the words that the exception would be when the purpose of that board or that position is to use your expertise or your connection or whatever. The purpose is to have that person in conflict because that's who you want to be on that particular board. I don't know how many boards there probably wouldn't be more than I hope not more than a handful where you're actually putting people in conflict on what they're working on. Probably, this may be the only board where you actually have people putting themselves in conflict by what the qualifications are for membership to the board.
I think, Councilman, that this is, the Ryan White Board is the most extreme example that we have because it's in terms of conflict, but it may be more prudent if we feel in the future that there are boards that we have to make broader exceptions for, that we make specific exceptions in the county code for those boards as opposed to trying to make a one-size-fits-all to fit that situation, because there are about 70 boards and commissions. To that level of conflict, you're really only talking about 2 or 3. And I think it would be more prudent for us to treat those boards individually.
Ms. Conwell.
And I agree with Mr. Glassburn, and I believe that the main purpose for this ordinance is basically because we do not have enough people that want to apply for these boards and commissions because the law is tying their hands. So I agree with Councilman Brady on that. I think we could just make sure that in the county code, as we're going along, if we see, like you just stated, if we see that there's some discrepancies, that they add that. And also, since we're trying to open up for more people to participate, and those that haven't and had many years to participate, if they all of a sudden want to start participating, that we give them a clear, shot at that. We don't, just because they haven't so far, we don't exclude them in the future when we open up. So that would be my only suggestion.
The one comment that I would make is that in the past, when we've had people come in for these boards and commissions, and it's clear that they're going to have so many conflicts that they're going to have to be recusing themselves on a third or a half of the legislation that comes before the board. Well, we've kind of backed off on those and said, do we really want to go forward on this appointment? So that's something that you really can't write into legislation, but I think it's an appropriate exercise of a confirmation process, working in collaboration with the executive and the appointee, and I think that can help resolve so that we don't have boards and commissions where the people can't do their jobs on the board. Are we ready for a motion for second reading?
Sure, Mr. Chair, I'll make a motion that we adopt, that we refer our resolution 2015-0012 to the full council for second reading.
Any further discussion? Hearing none, all those in favor say aye. Aye. Any opposed say no. It's so referred for second reading. Okay, thank you. Resolution 2015-0130. Ms. Janine?
Resolution number 2015-0130, a resolution providing for the submission to the electors of the County of Cuyahoga an amendment to Article 9, County Employment Practices, specifying the responsibilities of the Personnel Review Commission, reallocating some responsibilities to the Department of Human Resources, and prohibiting discrimination in employment in county government based on gender identity, and declaring the necessity that this resolution become immediately effective.
Thank you very much. We had a preliminary discussion of this resolution prior to introduction at the last meeting of this committee, and it was introduced at the last council meeting. And as the first step of our discussion this afternoon, I'm going to ask the administration to make any further presentation on behalf of this amendment that you wish, and it appears that our executive is going to do that personally, and I call forward Executive Budish to present to us.
Thank you, Chairman Miller and members of council. I've come personally to express my strong commitment to the reform process that's been initiated regarding Article 9 of the Charter, and to convey my conviction that this is an important matter that the citizens of the county should have the opportunity to vote on. Contrary to the rhetoric you may have heard, these reforms are about promoting accountability and better government. All of the amendments are about promoting better, more efficient government, and most importantly, they clarify that the PRC is not a separate branch of the government designed to set policy or budget priorities. The PRC is not a fourth branch of government to be a check on the authority of council or the executive. These are not about, and I quote, going back to the days of a corrupt regime. What we are most concerned about is establishing that the PRC is not and was never intended to be a super policy-making entity. It's an entity that enforces ordinances established by council through adjudication and employee appeals. These amendments make that clear. The PRC is not an organization that was intended to set budgetary priorities for the county. The PRC has two main responsibilities. One, to adjudicate employee appeals, and two, to administer a classification plan that has been adopted by council by ordinance. I'm asking that council review these proposals for what they are and put the decision to adopt or reject them in the place where it should be, in the hands of the voters of the county. I believe that urgency is important, but I also have heard from several members that they are concerned about moving this too quickly. And I try to be respectful and responsive to members of council and their concerns. So if members of this committee determine that they need additional time to consider this fully, we would be prepared to go along with that request. I would now like to turn the podium over, Mr. Chairman, to Law Director Bob Triazzi, if that's permitted.
Director Tarazi.
Thank you very much.
Thank you, Mr. Chairman, members of the committee. As the executive has outlined here, our charter does a number of things. It establishes the branches of government. It talks about the authority of the executive. It talks about the authority of council. It speaks very clearly as to the dynamic in terms of the separation of powers and the duties that are incumbent upon each branch of this government. Article 9 creates both the Personnel Review Commission and a Human Resource Department. Unlike other aspects of the charter, it does not clearly delineate. It does not clearly delineate the distinction between the Human Resource Department and the Personnel Review Commission. The amendments that we began to review with you at the last meeting is a careful delineation of the powers and the responsibilities of an effective civil service commission, broadly defined as a Personnel Review Commission, and the Executive Human Resource Department. When we look at the details that we put forward here, it's actually a fairly traditional delineation of those functions. It's important that our charter reflect those delineations and understand not only or carefully articulate the powers vis-a-vis the executive branch and the legislative branch, but also the PRC and the legislative branch. Day one, since when I first came to the county, the very first issue that I needed that was brought to my attention was a conflict. It was an interpretation conflict involving the PRC and the human resource. It was actually a conflict not between the PRC and the administration, but a conflict between the PRC and the executive or the legislative authority of this county. as to the appropriateness of this council passing through its ordinances a mechanism in which the administrative rules of this county were going to be reviewed. All right, so to the rhetoric that is manifested itself in this issue is not about expressing this, a power distinction between the PRC and the Human Resource Department and the executive. It's critically important that the lines of authority between this council and the PRC be articulated and identified. When you look at the amendments that we put forward, that is simply what they do. I mean, it is a careful delineation to avoid duplication and additional costs. What does a personnel review commission do, and what does the human resource department do? But more importantly, it articulates very, very clearly the relationship between this body, between the personnel review commission and this council. All right, the authority to create, working with the administration, public policy, particularly with regard to the human resources policy of this county. That is your authority. It's your authority through ordinance. And I quite frankly see that because of the way that the charter has been identified as being problematic in identifying these things, there's no better way than put it to the electorate to make that determination of what the power of this commission needs to be. Ed Morales, my colleague at the last meeting, Mr. Chairman, walked through the details of it. He's happy to do that again here today, more precisely here as to each section. But I've kind of given a broad framework here as to what the amendment purports to do. If you would like him to revisit that here today, he's here to do that.
That would be your call if we're giving the administration the latitude to present the amendment as you so choose. So if you feel that would be a good thing to do, you should do so.
Or I'll have Mr. Morales then step forward and briefly go through the matters that he had previously identified for the committee.
Okay.
Good afternoon.
Mr. Morales, thank you.
I have a couple of documents that I've prepared that I would like to share with you.
I'm sorry, Mr. Chair. Just a question as to how you wish to proceed. Or if Mr. Morales presents a point, will you then allow questions to that point, or do you want him to go through his whole presentation and reserve questions for the end?
I would prefer, if you're willing, that he complete his presentation and then take questions.
First of all, we prepared an introduction that discusses the purposes of the amendments, and you should have received that with the packet for this meeting. It contains some bullet points, and also we prepared a table that essentially lists those purposes and the amendments that fall under them. Some of the amendments have more than one purpose, and so I can clarify that as we go along as well. I also have an additional document that I would like to share with you regarding our current ordinances. This document contains a listing of current ordinances regarding employment practices, and also contains citations to the Ohio Revised Code and to the Ohio Administrative Code. And finally, I've provided to you a copy of the PRC's Administrative Rules 3.06 entitled Delegation of Certain Administrative Functions. So first, if you would turn to this document with the bullet points, and the table. Right? Again, the proposed amendments are intended to clarify the role of county council with regard to establishing human resources policies and systems, and to clarify the intent of the charter that the Personnel Review Commission is subject to the legislative authority of council. In addition, the amendments are designed to advance the stated goal of Article 9 to eliminate unnecessary expense and duplication of effort. These amendments allow the Personnel Review Commission to focus on its primary responsibilities of adjudicating appeals on employment matters and administering the classification plan for non-bargaining classified employees, without having to perform functions that are more effectively and efficiently performed by other entities, such as the Department of Human Resources or by other departments. Some of these functions have been for years delegated by the PRC to Human Resources through Rule 3.06 of the PRC's administrative rules, entitled Delegation of Certain Administrative Functions. Some of these functions, such as training of employees, currently listed in the charter as a responsibility of the PRC, training of employees in job functions, are not capable of being carried out by the PRC without extensive investment and duplication of effort, and have in fact never been performed by the PRC. Finally, we've included an amendment designed to promote inclusiveness and to prohibit discrimination in county employment, and that amendment is reflective of the Supreme Court's recent decision validating same-sex marriage throughout the United States. And we have included gender identity in the list of protected classifications for which there shall be no discrimination in employment in Cuyahoga County. You received a letter in which yesterday, I believe, in which there were certain points raised, certain critiques of the, or criticisms of the amendments, and I'd like to address a couple of those issues. First, there was a point regarding restriction and elimination of PRC responsibilities as opposed to reallocation of responsibilities. I think the proper response to that is that it's a matter of semantics and point of view, that indeed the amendments do reallocate responsibilities to human resources, but those responsibilities have been delegated in large part to human resources by the PRC currently, and also their responsibilities, some responsibilities, as I've said, that have never been performed by the PRC, like training employees in job functions. There was an issue regarding the language in the proposed amendments, including the word non-bargaining, that the PRC would have the responsibility to administer the non-bargaining classification plan. I would point out that the current ordinance of Cuyahoga County creating the classification plan is in Chapter 305 of the county code, and I've provided to you the index of Title III, Employment Practices, and you will see that Chapter 305 is entitled Cuyahoga County Non-Bargaining Classification Plan. So to the extent that there's there's concern about that, the response is, look, it tracks the current situation. Our current ordinance refers to the classification plan as the non-bargaining classification plan. Moreover, with regard to the other instance in which the jurisdiction of the PRC is specifically delineated as involving non-bargaining employees, it involves adjudication of appeals for employment matters. And the current jurisdiction of the PRC with regard to adjudicating employment matters is only for non-bargaining employees. And I have included reference to the Ohio Revised Code, Section 4117.10a. And in this statute, the state statute, the General Assembly has included the following language. if the agreement provides for, and they're referring to a collective bargaining agreement, if the agreement provides for a final and binding arbitration of grievances, public employers, employees, and employee organizations are subject solely to that grievance procedure, and the State Personnel Board of Review or civil service commissions have no jurisdiction to receive and determine any appeals related to matters that were the subject of a final and binding grievance procedure. Now, with regard, going back to the administration of the classification plan, there is additional language in the Ohio Administrative Code speaking to the issue of testing. And selections subject to collective bargaining agreements are specifically listed as a basis for which a civil service commission, like the PRC, would not implement a test. And that's in Ohio Revised Code 123:1-1701C2. So the bottom line is that the current duties of the Personnel Review Commission do not involve, in large part, bargaining employees. Terms and conditions of employment, including pay equity issues, are handled through collective bargaining negotiations. And an assertion or desire on the part of the Personnel Review Commission to set policy with regard to pay equity, or to develop a program or recommendations with regard to pay equity for bargaining employees would be disturbing to me, since those matters are in fact handled through collective bargaining negotiations, and should be for groups of employees desiring to be unionized. The next issue was that allegedly the PRC's oversight role is restricted. By the elimination of HR's reporting requirements, and this is an important point. You should be aware that the original charter included language in which the HR department actually reported to the PRC, was directly responsible to the PRC. I think from the beginning, from the first instance that the charter was made known to all of us, we recognized that that was an unworkable model, and it was not the model that was ever actually put into place. And in 2013, I believe it was, the charter was amended to delete that language. But unfortunately, what we did not delete, and we should have amended it, was language falling under the heading of the Human Resources Department. So we created a Human Resources Director through amendment of the charter, and we said, the charter says that Human Resources Director serves at the pleasure of the county executive. But at the same time, the language was left in the charter, which states that the PRC can delegate responsibilities to the Department of Human Resources, and then can require reports to be issued. All of these, the functions that are in 3.06, functions that are listed, PRC Administrative Rule 3.06, are functions that are listed in the charter, and the PRC has always delegated them to HR, and it's an example. It's of the duplication, really, of the ambiguity and the lack of clarity with regard to the delineation of responsibilities that exist in the charter. First, there's a Human Resources Director who serves at the pleasure of the county executive. But then there's a Human Resources Department that has delegated responsibilities from the PRC. And with regard to those responsibilities, the PRC is entitled through the charter to receive reports. That is the provision that was eliminated. We did that because the functions that the PRC currently delegates to HR, that are currently assigned to the PRC in the charter, have been reassigned to HR so that there is no corresponding need for the reporting that is currently included in the charter. I hope that's clear. Now, a point is made that the proposal deletes the PRC's authority and responsibility for assuring administration of compliance with laws regarding personnel matters. I would point out that if you look at the PRC's Administrative Rule 3.06, that's one of the functions that's delegated to Human Resources. In large part, it appears to me. The problem with the language is that it is vague and over-inclusive. It seems to establish the PRC as the entity that would have some responsibilities that are currently performed by HR, some responsibilities that are currently performed by the law department, and by the departments themselves in policing their actions. So the question becomes, what does administration of compliance with laws regarding personnel matters actually mean? I suggest to you that no one can really articulate clearly the boundaries of that language. I mean, does it include EEO compliance, workers' compensation? Does it include unemployment compensation, collective bargaining, wage and hour laws, health and safety laws, payroll, benefits, civil service laws, the federal Hatch Act, the state's Little Hatch Act, or myriad other laws that impact on personnel matters? It's not well drafted. And in addition, administration of compliance with these laws, that language is not well drafted. This may be one of the reasons that the Summit County Charter has actually, in some respect, been amended to emphasize where that language appears, the reporting of EEO statistics by a reporting unit, which is typically what we think of when we talk about administration of compliance with the personnel. With laws that a personnel department would be involved with. It would be an EEO officer reporting to the Civil Rights Commission and the EEOC regarding the composition of our workforce. So that's the reason that proposal is made. It's because the language is vague and over-inclusive, and because we seek to eliminate duplication of effort that occurs with human resources and the law department and other places. Finally, there is an argument that the changes allegedly destroy accountability and transparency intended to provide balance and protection in a strong executive form of government. That's a quote from the letter that you received. Look, balance in the county government is provided through the existence of a legislature and the executive branch, unlike a situation in other counties where the three commissioners serve both those functions. The legislature provides balance. It is the check on executive authority in this form of government, not the Personnel Review Commission. The Personnel Review Commission and Civil Service Commissions traditionally have, again, two functions. And those functions would remain with the PRC in the proposed amendments. Again, the adjudication of employee appeals, and secondly, the administration of the classification plan. And I should point out to you that those two functions represent the significant majority of the resources that are expended by the Personnel Review Commission. And they remain with the Personnel Review Commission. So again, what we are seeking to do is to clarify the function of the PRC to establish the legitimate authority of the council to legislate and exercise its legislative authority over the PRC, and to eliminate duplication of expenses and effort, properly and carefully delineate the responsibilities of the PRC and the Department of Human Resources, and also, finally, to improve upon the protections against illegal discrimination that are included in the charter. So if you have any questions, I'd be happy to take them.
Okay. Councilman Greenspan was first.
Thank you. Mr. Morales, I don't know if this first question is to you or Mr. Triazzi, but Mr. Triazzi made the statement. Who specifically on council raised the question? You said when you first started, one of the first things you were approached was by a member of council that there was a conflict between the PRC and HR.
Councilman, I misspoke. I was approached by the commission through their legal counsel. I misspoke by saying it was a member of council. It was a letter by counsel for the commission.
Okay, all right, thank you. The rules of the PRC, they've been codified, correct? Section 306. Mr. Morales, is that correct?
No. Chapter 306 is currently entitled Prohibition on Consideration of Criminal Conviction for Employment.
Then I've got my numbers wrong, but have the rules of the PRC been codified?
No, they have not.
They have not. Looking at section 902 of the charter, which is their authority, there are five sections. So the first one, obviously, it doesn't appear on the first two that there are any issues with those two. The number 5 specifically talks about council shall deem other functions as it sees fit. So I want to talk about 3 and 4, but I want to talk about 4 first. So 4 says that the Personnel Review Commission shall, so we're missing a word here, but be responsible for creation of rules and policies related to the Personnel Review Commission's authority set forth in the charter in accordance with the human resource policies established by ordinance.
Correct.
So council is the only one that can vote and establish ordinances, correct?
Yes, sir.
So if the PRC has the ability to create rules that are subject to adoption by council ordinance, isn't that already in the charter?
It is, but it hasn't been effective to keep the PRC from arguing earlier this year and really throughout the year that it has no responsibility to comply with the procedures for adopting rules that council has, or the council has adopted in the administrative rules ordinance.
Well, right,
So-
but and whether the PRC is subject to administrative rules board or not, and that's subject to discussion, because when this charter was created, there was no administrative rules board to begin with. The rules of the PRC, as explicitly stated here in the charter, shall be done by ordinance, therefore adopted by council. So we're not abdicating or in conflict with any
No, it
PRC action.
doesn't. It doesn't say that their rules shall be adopted by ordinance. It says that the human resources policies of the county are established by ordinance.
What's it, the responsibility for the creation of rules and policies related to the Personnel Review Commission's authority? So rules of their authority are established by ordinance.
It says responsibility for creation of rules and policies, yes, related to the Personnel Review Commission's authority set forth in this charter, and that those rules must be in accordance with the human resources policies established by ordinance.
Right, so
Agreed.
So part of the charter amendment was isn't that already in place? I mean, you're saying that their rules must come before the council.
We've sought to amend that particular provision to make it clear that the PRC, in addition to ensuring that its rules are in accordance with human resources policies established by ordinance, the amendment is that the rules would be in accordance with all ordinances passed by council, which then would eliminate the argument that the administrative rules ordinance is not an ordinance that the PRC needs to comply with.
Okay, maybe I'm missing it. I think that authority is already granted in number 4 to what the charter amendment seeks to do. It actually circumvents the administrative rules, which is a rules board, which is reviewed by the administration, and takes this right to council, to which is the appointing authority to the PRC.
Actually, I think the PRC, I'm not sure that the PRC would agree with you on that. I think that issue was discussed recently in another committee meeting in which the PRC was asked whether or not a representative of the PRC was asked whether or not they should be required or can be required to submit their rules to council. And I think that there was some hedging on that point, and a reference back to this section of the charter. What was said to you was that the PRC can promulgate rules that are in accordance with human resources policies as established by ordinance. But if you ask the PRC whether or not that includes the administrative rules ordinance, which by the way is referenced in Title III in a manner because Title III currently says that the PRC is to follow the procedures for creating rules, which is in our human resources policies and procedures. There's a link to the creation of rules and the process by which rules are created. The PRC would tell you that they are not required by the charter to follow the administrative rules ordinance. And the amendment that we're putting forward requires that the PRC follow all ordinances of council, thereby strengthening the legislative authority of council over the PRC.
But they're already required to submit their rules via ordinance.
No,
Pursuant.
they're not required to submit their rules via ordinance. Sir, you're misreading it. My apologies, but the human resources policies are established by ordinance, is what the charter says. Not their rules.
Okay, I'm going to have to look at that a little more closely then, because that's not how I'm reading Section 4. Now, I noticed in one of the provisions, one of the amendments, you're striking out a number of items: training, consistent coordination, compliance. Those last 6 items.
Yes.
It doesn't say the PRC shall conduct training. It just says they have the authority to ensure that training is being conducted.
Well, that's one of the ambiguities that I think the PRC would even agree. That's an example of the ambiguity that I think the PRC would even agree needs to be rectified. Although I'm not sure we would have the same answer with regard to how to rectify it. I think representatives of the PRC have said to council that this language, authority to ensure, is ambiguous and needs to be tightened. And so that's part of the problem, that the current language of the charter includes language like a vague language like authority to ensure, without really providing any type of mechanism for how that's done. And so
Well, let me ask you this. If the administration fails to provide information to council, what is council's remedy, i.e. relating it back to the PRC's remedy to ensuring compliance with an ordinance?
council has significantly more authority than the PRC to handle a situation like that. They can legislate.
But if the administration fails to provide council with specified documents by a certain period of time, what is council's remedy? Is to go to the prosecutor, I would assume, to have an order to compel compliance with the charter or with an ordinance.
That may very well be true.
I'm trying to think what else. I mean, we can't put somebody in jail. So what?
I'm not following you.
Well, my point is this, the ambiguity of this is no different than other ambiguities throughout the charter when either council or the administration or an entity is required to comply with certain provisions. If they fail to comply, what's the penalty? All it says here is that the PRC has the authority to ensure that these things are happening. And if I would assume that if it's determined that the PRC determines that training is not taking place, that they would approach the approach the administration. Yeah, maybe what's ambiguous here is what the remedy is, but not the verb, not the action.
The point that we're making is that the issue of training of employees in job functions, for example, is not something that is traditionally or appropriately placed under the authority of a civil service commission.
And I don't think this says that they're doing it.
Well, and therefore we're eliminating the language as being unnecessary and in avoiding duplication of effort. I mean, you've said that the language authority to ensure is vague, and therefore, so what? It's vague. There's no enforcement mechanism. Well, that's the problem in itself. If it's vague, we're not sure how the PRC is not sure itself how it should be undertaking these responsibilities. For example, we have the pay equities, the authority to assure pay equity for like positions. There's been a great deal of angst with regard to how the PRC goes about that. And so, we think that the better course is to carefully delineate the responsibilities of the PRC and the Department of Human Resources. And we also think, I would suggest to you that these functions are more appropriately traditional human resources functions. For example, the concept of standardization of benefits. These are human resources functions, and that the charter would be improved and our government would be improved by amending it to allocate the responsibility once and for all to human resources instead of the necessity of an administrative role entitled delegation of functions, in which it really is a fiction that the PRC has engaged in any meaningful activities with regard to some of these listed duties, specifically training for total quality management or training of employees in job functions.
I hear what you're saying. I'm looking at, they have 5 functions. Number 1, conduct appeals. Number 2, make sure we're compliant. Number 3, to have the authority to ensure that HR is doing 9 or 10 different things. Any rules they create or policies are by ordinance. And we can give them other authorities as council sees fit. I just continue to fail to see really the conflict here. It seems pretty clear to me. The one question I have is of this and previous administrations, have we been forthright in giving them the tools they need to do their job pursuant to the charter?
I don't know of reason to think otherwise.
Okay. All right, I don't have any other questions.
Okay, then,
Thank
we appreciate the presentation, and at this point, I'm going to call upon the PRC to make any response that you would like to provide for us.
Mr. Chairperson, members of council. My name is Robert Wolf. I have the privilege of having been the initial appointee to the then Human Resources Commission, now Personnel Review Commission, and have been serving on the commission since its inception and was the first chairperson. I'd like to address a few things initially and kind of take them off the table because I think they're non-issues, and then discuss the issue before us today, if I might. Budget priority, that word was used in connection with the PRC. Our role in budget is the same as every other branch of government. We come to you and we ask for an appropriation or an expenditure. Maybe we get it and maybe we don't. We have no power of the purse whatsoever, and there's no language in the current charter that would suggest otherwise. Check on council, that what we're doing is somehow intruding on council's authority, and that's something that we've heard as a theme, I think, by all the speakers today on this issue. Until the Administrative Review Board concept was raised, which, by the way, let's be very clear, our objection wasn't county council reviewing or codifying our rules. Our objection was, and the county prosecutor in a very strongly worded opinion letter agreed, that between our rules and county council was an Administrative Review Board comprised nearly exclusively of appointees of the law director of the executive, who would have the power to say yay or nay to our rules. Let's be real clear, that was our concern. Not council. Until the Administrative Review Board issue arose, our rules have come before you. Every suggestion you've made has been incorporated, and we anticipate that that will be the situation moving forward. In fact, members of council, since the charter amendment in 2013 made you the appointing authority for the Personnel Review Commission, we see this charter amendment as the infringement upon your authority, and certainly not our efforts to perform our duties as we see them created by the county council and by the charter. So I thank you for allowing me to say a few words on this issue. It's of the utmost importance to us, and I'm speaking to you on behalf of my fellow commissioners and our hardworking, wonderful staff. This proposed charter amendment, as many times as the word clarify might be used, it's not to clarify, it's to profoundly limit the good work done by this commission, and in the event of shenanigans or illegal activity sometime in the future, and we're not for a moment suggesting anytime in the immediate future, but sometime in the future, the good work that we could do and would need to do to fulfill our charter obligations should that occur. We are here to ask you to slow down the process. The proposed charter amendment impacts important checks and balances built into county government in our still baby charter. It's in its infancy. I agree with our county executive in one point. We don't need to go back through the history, the sad history of corruption that led to this new form of county government. It's still all too raw in our memories. But from that sad history, from that sordid history, you were created and so were we. We were created by charter and we came into existence in 2011. And we hit the ground running. I'd like to spend a very short time telling you what we have been doing, since what you've been hearing is what we're not doing, and Mr. Morales is right. We're not doing training, although the prior administration did let us know precisely what ethics training was being done to make sure that we thought it fulfilled charter obligations. We were appointed in March of 2011. Our first public meeting was the following month. At that time, as you know, the county executive was making large-scale changes to the county's classification plan, and a reorganization was in process. We worked hand in hand with the prior administration in properly classifying employees and ensuring they were in the appropriate pay scale. And we heard appeals from employees who believed they were misclassified or their rights were somehow violated in the process. We promulgated our administrative rules, presented them to you, and after incorporating your changes, they were approved. And after careful study, we've promulgated our testing rules, which we also intend to present to you, just not through an administrative review board comprised of representatives of the executive. We've adjudicated 275 employee appeals, 287 class plan changes have been reviewed, 30 HR policies, we've coordinated 2 pay equity studies, we've conducted an SAP data audit, we've created an enhanced civil service testing operation, and now that we've hired testing specialists and developed our rules for testing, we've administered 22 tests with 39 more in the pipeline. And I will posit for you, ladies and gentlemen, that for the first time, the County of Cuyahoga is giving tests for original appointments in our county service based on state-of-the-art validated tests that will pass legal scrutiny and are precisely what the voters anticipated. coming from the days of Russo and DeMora as to how employees would be hired into the county government. We have a testing team really second to none. We have 6 individuals with a master's degree in industrial or occupational psychology, master's degrees. This is the specific social science dealing with class plans, compensation, and testing, and validating tests. We are in daily contact with human resources, and we work collaboratively with each other to get things done. And recently, some of the appointing authority directors have had particular pressing needs to make emergency appointments, in one case due to a tragic death. And we have changed our emphasis and gone full speed to address those situations just in the last couple of weeks, one in the sheriff's office, one in the medical examiner's office. So let's talk just briefly about the proposed amendment. First point, when the charter was changed in 2013 and county council assumed the power to appoint us, and your subsequent appointments of Mr. Kolaluka and Ms. Sotherington are testament to your wisdom in exercising that right, we have become your appointees. So infringement upon our responsibilities and infringement upon our duties and scope of responsibility, don't be misled. It is a direct affront to you and your responsibility. We're told the purpose is to clarify. We've heard that word much as if it's a mantra. The language is confusing. We're just clarifying. Well, if one looks at a traditional civil service commission, there is probably no one power or indicia of what people expect us to do, what certainly the voters of our county expected us to do. But rather than appointing people coming into county government based on who they know or who they contributed to, or any one of a number of reasons that really are not good government reasons, it is expected that we will make original appointments. Well, we don't make the appointments, HR does, but we will provide the mechanism to make appointments based on merit and based upon fitness. There's no more basic a function that any civil service sort of commission can perform. The Ohio Constitution requires that appointments be made based on merit and fitness. The charter amendment, and so we're very clear what we're talking about, the amendments to section 9.02 limits our authority to test, not for promotions, but also for entry-level positions only to non-bargaining unit members. Why is that important? It's important because of the 4,600 employees reporting up to the executive, about 3,000 of them are bargaining unit employees. So this clarification would mean what is currently a regimen where we have tests developed in consultation with the appointing authority and HR that are validated for job relatedness. We have minimum qualifications, and we provide an eligible list of the top candidates for the executive and his appointing authorities to make a selection. Over half of those appointments will no longer be within our purview. They're back to the executive. If amended, as requested, the charter would allow the majority of such hiring to be back within the exclusive jurisdiction of the executive with no oversight. Mr. Morales looked at you and said, well, the collective bargaining law of the state of Ohio says this is all bargaining stuff. It's not even part of, excuse me, but I pulled up a statutory section when I was hearing him talk. You're not even allowed to deal with it. It's all from the union. I'm quoting to you from section 411708, matters subject to collective bargaining. Subsection B, the conduct and grading of civil service examinations, the rating of candidates, the establishment of eligible lists from the examinations, and the original appointments from the eligible lists are not appropriate subjects for collective bargaining. Our General Assembly, when they created the right of public employees to collectively bargain in this state, made one giant exception, and that exception was civil service commissions will give tests so that we can get lists of candidates and appointments can be made based on merit and fitness, and we are just one administration into this new county government, and that most basic of protections against patronage, that most basic of what the voters expected us to be doing, they are asking, and on an emergency basis nonetheless, to be taken away and given back to the executive. The charter amendment would transfer PRC oversight responsibilities to the HR department and eliminate the requirement that HR provide reports to the PRC regarding its operations. Significance, these changes destroy the accountability, transparency, and protections built into the charter to serve as checks and balances in the strong executive form of government. So the body created to provide oversight would lose all oversight responsibility. The body created to ensure testing based on merit and fitness would be restricted from the ability to test a majority of county employees. Ladies and gentlemen, this is not a clarification, it's an evisceration. Is it germane to this administration? I'm almost certain it isn't. These are wonderful people that are doing what they're doing because they care about government, they care about good government. But it's not about the Budish administration, it might not even be about the next administration or the next one after that. But it's about what the voters expected us to be doing in this new government. And that's why we're asking to slow down the process. Just from our differences in interpretation of what's being asked, we can see the vast differences between our position and the administration's, between our understanding of what the charter means and theirs. This requires a full vetting, a full public vetting. These changes alter a critical protection built into the charter. I submit that we should wait for the new Chief Talent Officer or HR Director to be named and include her or him in the debate, and perhaps a joint task force to study these amendments comprised of equal number of representatives from County Council, from our commission, from the administration, and to the extent there's ambiguity, to the extent there's overlap, let's take a look. But the way it has worked up to now is, if it ain't broke, we ain't fixing it. We're not dealing with training. The administration's done a wonderful job of training. But what we are focusing on are class plans, wage equity, and most important, having the safeguards in place pursuant to a charter that enforces those rights to make sure that those dark days of the early part of this century don't occur again in any of our lifetimes. So with that being said, I would be glad to answer any questions, and if they're over my pay grade, I may ask one of our attorneys to take a stand.
Council President.
Thank you, Mr. Chairman. Mr. Wolf, thank you for your comments and your response to the administration's presentation. At several points during your presentation, you rightfully referred to the fact that the voters in Cuyahoga County had certain intentions and expectations from the new government that we collectively formed. And as you say, the reason we're here, the reason you're here. That said, and I would agree, isn't it also true that if an amendment were to be placed on the ballot, that the same voters that we all have so much faith in to make these decisions would be the ones who would make the final decision on this?
Absolutely, but I would submit, sir, that should only occur after this body has the full opportunity to carefully consider all of the proposed changes that are being suggested. This might not, after a full, robust debate, be what the county council believes ought to be submitted to the voters. But no, eventually, if it's returned as a charter amendment in front of the voters would get to decide. I would submit there's not the same great mass interest that there was initially, but no, of course, it would go back to the voters. But I think we can share the concern that what is submitted to the voters is the very, very best charter amendment that can be submitted, and this language I would submit is not such a charter amendment.
All right, thank you.
Thank you.
Any other? Councilman Germano.
I'm just wondering, because really this is complicated.
No kidding.
Because you know, both sides of the story sound like good sides of the story. So how do you sort this out? A lot of this seems to make sense in what is proposed. Isn't there some parts of this that the PRC is in agreement with? I mean, if we could sort out what makes sense and what you agree with, and then
Right.
instead of looking at this whole thing, just try to have the ones where the definite disagreement is, and then I'm just wondering if it's theory or if it's word grafting.
I think, I'm sorry.
That the argument is over, and I can understand that if it's in theory and it's not really in the words, then we should be able to get together on this. So that's one thing I'd like to see. I'd like to see what we agree on, and then that makes things easy. Then all we got to do is decide about the things that are very objectionable. The only other, and I've said this before, I think the charter in all that, people voted on, I mean, they only had one vote. They didn't have 50 votes on decide what they like in the charter and what they didn't like. They just voted against corruption, fix corruption. And I think up until now, the process that we've gone through, deliberations, communications, open meetings, going out to the hinterlands on charter revisions, is we've heard from the people, and what needed to be corrected, we've made some great. So when people voted for the charter, it was in sum. So we just can't say that this is like the Bible, every word is infallible. So we're just trying to improve it. So I'm still trying to grasp, because both explanations made a lot of sense to me.
Can I comment on that? If I may, I think you're right. And I think we ought to sit down and we ought to see what common ground there is, and we ought to see what ambiguities there are, and take a stab at addressing them. But I think our three bodies ought to take a stab at seeing what we can agree to first. But you're right. They voted on it as a package, and people weren't, and it's not like the Talmud where there are scholars debating what every paragraph means, every day. So I think your point is a very good one.
Okay. I'd like to now call upon Ms. Durkin to make any comments as you wish on behalf of the department. Okay.
Thank you, and I thank the committee for allowing me to make comments. I think this is certainly a complex issue and a complicated one, and one that I find myself kind of walking a line on. I was with the Department of Human Resources back in 2011 and sat with the original Human Resources Commission as they promulgated rules and as they put into place the first ever rules and operations that they were going to work by, and I learned a lot during that period, and looked back to the charter a lot, ourselves to see, to try to interpret, intent and the like, and then, and coming forth through a number of years and working with the administrations and working with the PRC as they are now. And, I say that I have had a very good, what I consider to be a very good working relationship with the PRC, and it has been my pleasure to work with them. I have watched them, I think, efficiently give impartial redress to employees in the form of appeals. And I have now watched them implement testing, an across-the-board testing system for the first time in this county, and I have watched them, struggle with resources and time and the, emergent needs of this county as that has been put into place, and we continue to work together, and it's my pleasure to work with those professionals on that, and I look forward to working with them on their administration of the class plan as well. I guess, though, when I look at the situation, I feel that it is incumbent upon me to look at the situation as the interim director of HR and as a representative of the employees of Cuyahoga County. And I know that the employees of Cuyahoga County are always looking for, and what is most important to them is that avenue where they can seek impartial redress. We heard that all through the Gallagher study, sitting and doing their employee focus groups. We heard a lot of times where the employees were saying that they did not see a break in the line between HR and PRC, or they didn't see a break in, they sometimes didn't believe that they were going to receive impartial redress. Now, I know that the PRC, I believe, has actually done an outstanding job in that capacity. As I look back to our charter, and when our charter was authored, I believe that, like everyone else, the author's intention was to err on the side of giving separate places where people can go to get checks and balances and make sure that impartial redress can occur in employment matters. I do see in the charter where clarification can be very useful in our existing employees' minds and our future employees' minds. They can continue to go to the PRC and get impartial redress on that. Now, if that means that we clarify language of, who is training employees on their work, who is adding to or administering policies and procedures, that clarification needs to be made so that the employees can be ensured that when their appeals are heard in front of that board is separate from where the decision was personally put upon them in the HR. So that is, I guess, what I wanted to say today.
Thank you very much. I'll now open the floor to questions or comments, questions to any of the presenters, and I'll start with Ms. Conwell because I know you had one on request.
Through the chair to Mr. Wolf, Commissioner Wolf, you spoke about, I believe at the beginning, the training, how the administration kind of stated that they want to strip the PRC from these three things that address training, and you stated that you haven't really touched training. So if you could go into that a little bit.
So, as we all know, the charter did, as Councilman Greenspan pointed out, enumerate quite a few responsibilities that we are required to ensure. We started with no infrastructure, and we're required, although it was victims, to work very closely with HR as we all.
Thanks, Lisa. As we all came to speed into the new administration. There are statements in the charter about our responsibilities in regard to training. The way we dealt with those and under the last administration was we were brought into the loop to review the ethics training that the last administration gave. And had we said, we don't think this is any good, I don't know if it would have been changed, but we didn't say that. It was really good, effective ethics training, and we were in the loop. Since then, Ed's right, that is not something that we have focused on as training, and I think the executive has But I also think that the charter authority would be important if there was to come a time when ethics training was no longer given. And again, it's not going to be this administration, we know that, but it might be another in the future. So I do think there's an independent significance to the safeguard role, but everyone that's pointed out that we're not actually going and training employees are correct. We're not doing that.
Well, and that was my concern. You know, to me, that was kind of like a give or take moment in this resolution, where you could, if you're not doing it now, would there ever be a possibility that you would ever do it? And if not, then that's like meeting the administration halfway just on the training component. And I say that to say, because some of these, I'm in agreement that the administration, they might be more HR functions versus PRC function. Where I disagree with the administration is the rush job and not fortifying the residents of Cuyahoga County to be able to come in with public comment that is related to the changes that, no matter what was put in there and why we elected to have the PRC, it was put in there. And so this is a document that we must work from, and we can't easily eradicate it just because we want everything to be so succinct. So I'm very shocked that we haven't gotten along in communication between the two organizations, and now we're forced to put it to a vote for the people, and it's not even, I think, worked out in-house amongst. My suggestion is it's not ready, nowhere near ready to go to the people if we can't communicate it amongst ourselves, first of all. And I am inclined to, I suggested to the Councilman Brady and to Councilman Miller, maybe we should have more open and transparent hearings between council operations as well as HR. Even though it's an amendment and it falls in his committee, it directly affects HR committee. But I am inclined to, if whatever the president wants to go with this, if we just vote on it now and then work on things later, or basically we need to all sit down like adults and sit and talk these out. And from the inception of this new form of government, I think county council, as well as the administration and PRC, has done a great job, whether it was the personnel policy handbook, the department review board, whatever that would set rules forever. We had open hearings and we had dialogue, and things transposed and everybody said their say, and we had good working documents that came out of that. And it's a long process, and it's not a quick fix, but it worked. It worked for the people, and it worked for the future of this government body. And so that's why I'm more inclined to stay on that pattern that we have set up initially, and good work comes out of it. And at the end, thank you.
Okay. I'd like to ask a question of Mr. Morales. The question is on the comments made by Mr. Wolf regarding 4117.08 regarding civil service appointment of eligibility lists, original appointments, whether you agree that that area is carved out of bargaining, and that the proposed amendment would take away the PRC's authority to create eligible lists and do a civil service process in that area.
We included the words non-bargaining in a couple of places in the proposed charter amendment. One was when we were referring to the classification plan. And that tracked the existing ordinance of the county in which the classification plan is referred to as the non-bargaining classification plan. That is the existing section 305, or rather chapter 305 of our code. The second place where we referred to non-bargaining, that the PRC would have authority to hear appeals of non-bargaining employees, and that tracks the existing jurisdiction of the PRC. They have currently the authority to hear appeals of non-bargaining employees. They don't hear appeals of bargaining employees or adjudicate appeals of bargaining employees who are subject to a grievance process and arbitration. And when I referred to 4117, I pointed your attention to 4117.10A, which clearly states that Civil Service Commission has no jurisdiction to hear appeals for employment matters covered by a collective bargaining agreement. The amendments were not intended to change the role of the PRC with regard to testing. So to the extent that the PRC has a legitimate interest in role in testing for original appointments of even bargaining employees, I understand the objection there. I see the point that they are making. I would say this: the administrative rules, the Ohio Administrative Code, however, provide that the selection processes that are in a collective bargaining agreement would supersede that authority in any event. So to the extent that the collective bargaining agreements deal with that issue, and many of them do, at least they deal with promotional appointments, that the collective bargaining agreements would prevail. But yes, 41708 does say that original appointments, new hires, the testing of new hires is not a subject appropriate for collective bargaining. That is true.
Thank you very much, Councilman Germano.
Mr. Morales, concerning the training.
Yes.
Okay, so I think the position of the amendment is that the PRC has nothing to do with training. So what I'm wondering is, in a situation of bad training, maltraining, I don't want to bring up, well, I'll bring it up. Cleveland Police, there's talk about inadequate training. We don't have policemen trained for the mentally ill, the addicted. Urban counties have more of that than rural counties. So it's maltraining or not enough training. Whose judgment is about the quality of training or bad training? Because you take Health and Human Services, these are the people with problems, the fragile people. Are we doing? I mean, are any of the arguments that I was not trained, or the rules that you require me to deal with these people is maybe against current thinking or new modern thinking? It's old thinking, old school, this is new school. Who deals with the quality of training or mistraining in all these different departments that we have.
The amendment is designed to promote better government through clarifying that it is the function of human resources with regard to human resources training, right, to human resources policies and procedures, which is, every organization, almost all organizations deal with it in this way. The idea is that by clearly establishing who has authority over training, that the better training could occur. If you understand who is accountable, then those folks can be held accountable. But even if there was poor training and the PRC did nothing, how is the PRC going to be held accountable? How does that happen? What needs to happen is the entity that is responsible for delivering the training needs to be in a position to be held accountable. And also, the fact that they are responsible for that training needs to be clearly stated. The current situation is that we have a Department of Human Resources, and we have a Director of Human Resources who is answerable to the executive appropriately. And we have a Department of Human Resources under the current language of the charter, which is in part answerable to the PRC over the delegated function of training. Organizationally, that doesn't make sense. If the Human Resources Director has the job of making sure that training occurs, she needs to be answerable. In this case, our interim director is answerable to the executive for that fact, and the charter should reflect that reality and it should be clear, and that's what we're seeking to do. To make certain that those individuals who have primary responsibility for those functions, that's clear from reading the charter, so that if there isn't good training, then the Director of Human Resources is accountable for that with regard to HR policies and procedures. Now, with regard to operational training, the current language, training and job duties, it puts the PRC in an untenable position when you think about it. They have no knowledge, really, about how the work is to be done or what training is appropriate to ensure, for example, that the sheriff deputies don't engage in a misuse of force, or that a social worker in the human services is properly following the requirements of the revised code with regard to handling abused or neglected children and how those situations should go. There's no expertise at the PRC with regard to the type of training necessary to make so that our employees optimally perform their duties to the betterment of the community, right? The responsibility for training of a social worker rests at the Department of Children and Family Services. And that responsibility, the charter should reflect that reality. And if a social worker at the Department of Children and Family Services has not been properly trained, the leadership of the management team at the Department of Children and Family Services should be held accountable. And that's how it is done. But by adding this authority to ensure language in the charter, you're really not doing anything but muddying the picture, muddying the water. Excuse my mixed metaphor.
Councilman Greenspan.
Just to, I think you were someone making my point earlier, but training itself is defined in the charter as being a duty and power of the Director of Human Resources, not the PRC. I don't know how much more clear that could be. It clearly says it in the fourth line of the duties and powers on page 906. If there's any ambiguity, I would argue that it's in what does it mean to have the authority to ensure, not who is responsible for training. and the quality of training, you're right, the quality of training, does a PRC, I don't necessarily see in here where the PRC has the duty to ensure the quality of the training, just to ensure that training is taking place. So I still don't see the argument.
I know you don't see it. I'm not sure that I can make you see it any clearer because I don't have any more explanation than I had earlier,
Okay,
sir.
all right.
But all I would say is that there are two charter provisions covering the same ground purporting to give two different entities responsibility over training. And we seek to clarify the charter by clearly delineating that it is the human resources function, and there's really no need for this authority to ensure, because it's actually a fiction that that authority to ensure is exercised.
Council President.
You know, we've had several amendments to the charter that we've forwarded over the last few years. We've discussed many more than we've actually forwarded. And although it's taken some time in some cases, not most really, the council is pretty likely to know what it wants to do if it understands clearly what it is that's being discussed. And while there may be some division in the council about any particular charter amendment, and there has been, it's generally a consensus of whether to go to the ballot or not to go to the ballot is pretty easy to read. This issue is clearly, at least in my perception, more complicated than some issues that we've gone to the ballot over, and we certainly had quite a bit of discussion over many of those issues. I have an open mind on this issue because I don't have that strong sense of where we should go. What I would hope that we could do would be resolve this, and it's been my opinion for quite some time, but more focused now, that we should be able to resolve this in-house, so to speak. I'm not certain yet why we can't achieve that goal without going to the ballot. But beyond that, my personal opinion, observing the council and discussing the issue with some members, is that there's not a clear consensus to go to the ballot over this issue this year. And there's not enough time, probably, to reach that consensus. And I think, though, that the administration, by introducing the legislation, raising the issue, the executive coming before us and making a presentation, making it clear in public, in a public meeting, how concerned he is and that it's important to him, certainly should get everybody's attention. It's got my attention. And I believe that if we're not able to work through these issues, and I'm hopeful that we will be able to, that if we're not able to work through these issues, then I'm not opposed to going to the ballot to clarify this issue. But there is going to have to be a consensus of the council to get there. I don't believe we're there. All the presentations from both sides make me want to ask a lot of questions. And I could see this taking some time. And that's what I think that we should do, is take some time. And so, Mr. Chairman, I'll leave this up to your judgment here, but I just want to express myself. I don't think we're going to the ballot this fall, but I do consider this an important issue that we should decide how we're going to approach and have a discussion and get some clarity, at least between ourselves, what's real and what's imagined from our side and the other side. So I just wanted to, I've been, as the administration indicated it was going to bring this forward, I've been able to give this some thought. I've been able to talk to some council members about it, and I don't think that the consensus is the clarity that provides the consensus in the council exists at this time.
Mr. Chairman,
Yes.
if I may address Council President for a moment on that issue. Just briefly, I would say thank you for your comments. I certainly understand the points that you've made. Obviously, I would hope, as really the primary author of these amendments, and here speaking to you, that we would be able to convince you of the merit of these proposed changes that I firmly believe in. But I don't think that it's a matter of sides on this. I think each side desires that there be a charter that provides the best possible government we can have, and that's the purpose of these amendments. And I would only echo what the county executive said earlier, that if council believed that additional time was necessary to discuss these amendments, then absolutely that's the appropriate way to handle it. And I have no objection to that. And I certainly understand the point being made. We don't want there to be an appearance that this is being rushed. That's certainly not the intention. We thought that we would take this opportunity to introduce the amendments based on the fact that there was just a single other amendment that was being proposed, and that there was a committee hearing and an opportunity to introduce these important amendments. And in my opinion, if we have achieved getting your attention on these matters, then that's absolutely a success, and we look forward to ongoing discussion about these matters.
Any other comments by my colleagues? I would just,
Mr. Chairman,
yes.
if I just could reiterate, I personally would like to know if there's any of these suggestions that the PRC agrees with. We could take those things off the table, so that would be helpful. Or if there was a way of tweaking the verbiage to make it more palatable, because if we could get agreement with both sides without having to make a ballot decision, then that'd be great. So
My views are similar to those of both the council president and Councilman Jumana. We've tried in this county government to work by consensus whenever possible. And I think something like 95% or more of the votes taken in this council end up being unanimous. And I think there needs to be a process where the executive and the PRC and the department sit down and work together and try to identify where there's common ground and where there's differences, and where there's differences to see if they can find solutions that everybody can live with, and hopefully that process might improve the working relationship between the parties generally, which would be beneficial. I certainly agree that that there comes a day when you've talked for a long time and you've discussed an issue thoroughly, and there may be points of difference that still stand out there that can't be resolved, and there comes a day where you just have to call the roll and follow the majority. But I think today is not that day. I think that we have a ways to go, and I certainly am totally supportive of the suggestion that Ms. Conwell made that the Committee on Human Resources and this committee could work together and see how we could help facilitate that process, and as to how soon we would come to a resolution, it would be as long as it takes. I think that that remains to be seen. I do think that the administration has made a point that that there are areas in this section of the charter that could be more clear. But there are also sections in the charter delineating the duties of the law department and the prosecutor that I still believe could be more clear. But in that case, at least for now, we've through collaboration and compromise, we found a solution that did not require us to go to the ballot. So I hold open the possibility that that kind of a solution might be possible here, or if we need to go to the ballot, hopefully it can be on something that either all, or if possible, or if not, that most of the points might be subjects of general agreement. And I think that would enhance the prospects that the voters would approve the amendment as well.
Mr. Chairman?
Yes, Councilman.
As you spoke, it occurred to me when you brought up the 95% agreement. Earlier this council, and basically it's pretty much the same council that we started with, there was a time when I think a majority, now it wasn't a vast majority, but I think a majority of the council wanted to have a charter amendment about the law director and the prosecutor. And there was a strong sentiment that this should be a revision of the charter to figure this out. And what we came up with is a memorandum of understanding that has given us time to get through this. I just bring that up of maybe this is the time to have a memorandum of understanding between the administration and the PRC.
Any other comments? I think that there's consensus within this committee to hold the legislation in committee for now, and we'll all work together on what the next steps should be. Has anybody signed in for public comment?
No, Mr. Chair, no one has signed in.
We're just barely within our customary 2-hour limit. Is there a motion to adjourn? Is there a second? All those in favor say aye. Aye. Thanks, everybody.